Darlene Morgan here, Morgan Law Group. Today we're going to talk about 5 tips to get families started on estate planning. So oftentimes people put off estate planning, either because they think it doesn't apply to them, maybe they think they're too young, or maybe they think that they don't have enough assets, but planning ahead is prudent and responsible, because we never know when something unexpected might happen. So the 5 tips start with, number 1, you're going to want to name someone to be in charge of your money. So that's called different things. You might hear it called a trustee or an executor or a power of attorney, depending on what documents prepared. But basically it's a similar job in that you're choosing a financial decision maker, someone who would step in for you if you couldn't manage your own finances. And of course you're going to want to choose someone who's trustworthy, as well as someone who's willing to take on that responsibility. Step 2 is you're going to want to think through what would the instructions be for distributing your assets. Now, of course, an estate planning attorney can help you figure that out if you haven't thought about it. But it's really, if something happened to you and you're married, how would you want your assets to get to your spouse? If you don't have a spouse or your spouse is predeceased to you, how would you want your assets to get to your kids? So those are the, really the big questions, or other beneficiaries. If you don't have kids, how would you want to get your assets to your beneficiaries? Most of the time, of course, if you're married, you want it to go to your spouse, and then find the best way of getting any assets to your kids after that. Blended families have some special considerations, and we do have a lot of blended families here in Southern California. So if that's you, and you have perhaps married to someone and you both have kids, or one of you has kids from a different relationship, then we really need to think through some of the special considerations for you, and making sure that we would get the right result. Third, we want to make sure that you name a guardian for your minor children. So if you do have kids under 18 years old, and especially if you have really small children, then we want to make sure that we've named who would raise them if something happened to you. For some people that's an easy choice. For some people that's a very difficult choice. We do help people get to an answer. For people who, they really can't decide, maybe you put the decision off because you really just can't decide who you would pick. We have a process here for getting you to an answer, because not naming anyone is not a great option, because if you don't name anyone, then you're leaving it to chance, or you're leaving it to a judge to decide. Deciding who would raise your children if something happened to you is one of the most difficult decisions that a parent has to make, but it's critical, because if you don't name guardians, you could leave the family to fight over it, and the kids can end up in Child Protective Services, or they could end up with someone that you would not want. So that's step 3. 4 is planning for disability. So we do a lot of planning here in our firm for what would happen if there's an incapacity, meaning you are not able to manage your own affairs. And I think that's a critical conversation to have, because this would be a time, I tell people the good news is that we're all living longer. The bad news is that because of that, we really need to make sure that we have a solid plan in place for that time frame where we might not be able to manage our own affairs. And having somebody with legal authority, valid, updated legal authority to step in is so important, because we live in a complicated, complex world these days, where that legal authority is necessary, because if it's not in place, then the court is going to have to get involved. And typically that is not what people want. So planning for an incapacity or disability, both financially as well as medically, is very important to getting started on your estate planning. Step five is to choose the right attorney. Not all attorneys are the same, but how do you choose? It can be a daunting task to try to make sense of it all, and understand what apples to apples is. Make sure that you ask the right questions when you sit down or when you interview to ensure that you are engaging a trusted advisor who's going to be there for you, for your family, when you need them the most, and who's really going to guide you to making the right decisions for your family. Someone who's listens and who can offer advice and make recommendations, and who can help you really get through this process as easy as possible, and as informed and educated as possible. And you don't want to judge by price alone. Honestly, there's an entire spectrum of costs when it comes to law firms and how much an attorney charges for an estate plan. And of course, it's difficult sometimes to figure out apples to apples, but usually the cheapest is not the best, and usually you wouldn't need the most expensive either. But I do encourage you to choose the right attorney and to take the time to find out who would represent your family in the best way in your particular circumstance.